How would you put it?
Well, where we are right now is the judge prepared what we call the charge of the court, which is the instructions to the jury, what the charges are and what the law is and the definitions of the particular charges like murder and manslaughter. And the judge included an instruction of an assault, a misdemeanor assault. And so amongst all the other instructions, definitions, and just the general thing that would be included in any instruction to the court, the state has now objected to the judge including the lesser included offense of an assault. And rather than accepting and being satisfied with just objecting to it and then hearing whatever the judge's ruling is, they want to now stop the proceedings and they want to file what we call an extraordinary writ. Some people call it mandamus, some people call it mandamus. But this will have the effect of stopping the trial. The jury will not even hear what the current charge of the court is. The state will prepare their own writ application to the higher court. And the higher court will consider it, and they'll consider it on an expedited, a rather speedier track, so that we don't get holed up too long in our trial process, and that we can still keep some sort of pace along and try to get some resolution to this case.
What higher court is that?
Well, we don't know. They may take it to an appellate court. They may take it directly to the Supreme Court, the highest court. Because this is still a juvenile proceeding, certainly the judge believes that ultimately it could go to the Texas Supreme Court, but it could go to the Fourth Court of Appeals in San Antonio as an appellate court. Our usual criminal cases would go to the Third Court in Austin before they would then go to the Court of Criminal Appeals, which handles all criminal matters, rather than the Texas Supreme Court, which handles civil matters.
And you feel assault should be included because?
We requested an instruction for an assault because we believe there was clear testimony from my client that the only reason that he hit Logan Davidson was to stop him from doing the things that Logan had been doing to him, including assaulting over the course of 2 prior days. So we thought it was appropriate for the jury to have that to consider amongst the murder and the manslaughter charges. We also felt, for instance, that we believed that there was some evidence enough to support